Since June 23, 2022, every gun law in America has been evaluated under one constitutional test. One test. Federal law, state law, city ordinance, it does not matter. If a law restricts conduct covered by the Second Amendment, it must pass this test, or it is unconstitutional. No exceptions. The test does not care how popular the law is. It does not care how many legislators voted for it. It does not care how many public safety studies support it. It does not apply a balancing test where a court weighs the government's interest in public safety against your right to bear arms. That kind of analysis is gone, permanently. Replaced on June 23, 2022 by the Supreme Court of the United States in New York State Rifle and Pistol Association versus Bruen. Every case this channel has covered runs through this test. The suppressor lawsuit, the AR-15 case at the Supreme Court, the 18-year-old handgun ban, the Hemani marijuana ruling, the DOJ lawsuits against Virginia and California. Every single one of them is being decided under the Bruen framework. If you want to understand any of those cases at the level of precision they deserve, you need to understand this test first. Most gun owners have heard the word Bruen. Very few can explain what the test actually requires, why it replaced what came before, or what it looks like when a court applies it to a real law. This video closes that gap completely. Let me start where the test started, not in 2022, but in 2008, because you cannot understand where the law is now without understanding where it came from. In June 2008, the Supreme Court decided District of Columbia versus Heller, 554 U.S. 570. Justice Antonin Scalia, writing for a 5-4 majority, held for the first time in American history that the Second Amendment protects an individual's right to possess firearms for traditionally lawful purposes, including self-defense in the home. That ruling overturned the District of Columbia's handgun ban. It was a landmark, but Heller left a critical question unanswered. Once you establish the individual right, how do courts actually evaluate laws that restrict it? What is the test? Scalia's opinion said means end scrutiny, the balancing test courts use to evaluate restrictions on other constitutional rights, was incompatible with Heller's holding. He said the Second Amendment is not subject to interest balancing, but he did not replace interest balancing with a clearly defined alternative test. He described the historical analysis that Heller used, but he did not set it out as a step-by-step framework courts could follow. Lower courts filled that vacuum for the next 14 years with a framework of their own construction. Not mandated by Heller, not authorized by any Supreme Court decision. Built by circuit courts trying to operationalize a ruling that had not given them a clear methodology, here is how that lower court framework worked. Step 1. Ask whether the regulated activity fell within the historical scope of the Second Amendment. If yes, move to Step 2. Apply intermediate scrutiny or strict scrutiny. Weigh the government's interest in public safety against the individual's Second Amendment right. If the government's interest was important enough and the law was substantially related to that interest, the law survived. The problem with that framework is fundamental, and it is not subtle. It let judges decide gun cases by balancing policy preferences. A court could uphold virtually any gun restriction by saying the government has an important interest in public safety, and this law is substantially related to that interest. The Second Amendment became, in practice, whatever a judge's policy calculation said it was. That is not a constitutional right. That is a privilege subject to revocation whenever the government makes a sufficiently compelling argument for safety. The Supreme Court watched 14 years of this, and then it took the New York case. New York's licensing law required anyone who wanted a license to carry a concealed handgun in public to demonstrate a special, particularized need for armed self-defense, beyond the general desire to protect oneself that applies to every citizen. In practice, this meant that ordinary, law-abiding New Yorkers could not obtain a carry license, no matter how responsible they were. The right to carry in public simply did not exist for the vast majority of New York's residents. The Second Circuit upheld the law under the old two-step intermediate scrutiny framework. The Supreme Court agreed to hear the case and used it not just to resolve New York's carry law, but to permanently dismantle the lower court's balancing framework and replace it with a new constitutional standard. The decision in New York State Rifle and Pistol Association versus Bruen, 597 U.S. 1, was authored by Justice Clarence Thomas and joined by 5 other justices, 6-3. Decided June 23, 2022. Here is the test, stated exactly as the Supreme Court wrote it. When the Second Amendment's plain text covers an individual's conduct, The Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. That is the complete test. 2 sentences, 2 steps. Let me take you through each one with the precision this standard requires. Step 1 is the challenger's burden. To trigger Second Amendment protection, the person challenging the law must show that the Second Amendment's plain text covers the conduct being restricted. The operative clause of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." 3 terms carry the constitutional weight at step 1. Who are the people? What are arms? And what does keep and bear mean? The people. The court has consistently held this means law-abiding, responsible citizens. It is the same the people referenced throughout the Bill of Rights. When the government argues that a particular class of Americans falls outside the people, drug users, nonviolent felons, domestic abusers, that is a step 1 fight. The Hemani case, decided 9-0 on June 18, 2026, was partly a step 1 question. Does a marijuana user who has cooperated with law enforcement, committed no violence, and holds a stable job remain part of the people covered by the Second Amendment? 9 justices said yes. On those facts, on that record, arms. This is where the AR-15 fight lives. Viramontes versus Cook County, where the Supreme Court granted cert on June 30, 2026, is almost entirely a step 1 question. Is an AR-15 platform semi-automatic rifle an arm within the meaning of the Second Amendment's plain text? The plaintiffs argue yes. More than 30 million are in civilian hands. They are in common use for lawful purposes, and that is all Heller's common use standard requires. The government argues no. These rifles fall into Heller's M16 and the like military weapons carve-out, and are therefore outside the Second Amendment's plain text entirely. The Supreme Court will answer that step 1 question before June 2027. Keep and bear. Heller established that keep means possess in the home. Bruen established that bear means carry in public for self-defense. The right to acquire, to purchase arms, is necessarily implied in both. You cannot keep what you cannot buy. You cannot bear what you cannot obtain. This is why the 18-year-old handgun ban is a Second Amendment question. The ban does not restrict possession. It restricts the commercial transaction through which 18 to 20-year-olds would exercise their right to keep arms. If the challenger clears step 1, if the plain text of the Second Amendment covers the conduct is presumptively protected. The burden shifts entirely to the government, completely. The challenger does not have to do anything more. The government now has to justify its law, or the law falls. Step 2 is the government's burden, and this is where the old framework died completely. The government must demonstrate that its regulation is consistent with the nation's historical tradition of firearm regulation. Not that the law serves an important interest. Not that the law is substantially related to a compelling governmental purpose. Not that the benefits outweigh the costs. None of that. The government must produce historical evidence, actual laws, actual regulatory traditions, showing that the kind of restriction it is imposing on gun owners today is consistent with what the founding generation understood to be a permissible regulation of the Second Amendment right. The government must find what lawyers call historical analogs, laws from the founding era or the Reconstruction era that are relevantly similar to the modern restriction being challenged. And here is the critical standard for what relevantly similar means. The court held that the test looks at both the how and the why. How did the historical regulation burden the right to keep and bear arms, and why did it do so? Both the mechanism and the purpose must align with the modern law. A historical law that restricted firearms for a different reason, or burdened the right in a different way, is not a sufficient analog even if it superficially resembles the modern restriction. The founding era is 1791, the year the Second Amendment was ratified. That is the primary reference point. The Reconstruction era, 1868, when the 14th Amendment incorporated the Second Amendment against the states. Yes, there is a secondary reference point. Laws from the late 19th century carry decreasing weight. Laws from the 20th century, 1934, 1968, are not historical tradition in any sense the court will accept. They are modern regulations that themselves need historical justification, not historical justification for other regulations. The historical analog does not have to be identical to the modern law. Bruen said the government does not need to find a dead ringer from 1791. But the court also warned that courts cannot uphold every modern law that remotely resembles a historical analog. Doing so would risk endorsing outliers that our ancestors would never have accepted. The analogy must be genuine. The principle must be real. In 2024, the Supreme Court refined how analogical reasoning works in Step 2. The case was United States versus Rahimi, 602 U.S. 680. Zaki Rahimi was subject to a civil domestic violence restraining order, a federal law, 18 U.S.C. Section 922 G 8, prohibited persons under such orders from possessing firearms. The Fifth Circuit had struck the law down under Bruen, finding no sufficient founding-era analog. The Supreme Court reversed 8-1 and upheld the law. The Rahimi clarification is important, and I want to give it to you precisely. Some lower courts had read Bruen as requiring a near-identical historical law, a 1-to-1 match from 1791. Rahimi rejected that reading. Chief Justice Roberts, writing for the majority, held that courts should examine historical analogs collectively, look at all of them together, identify the underlying constitutional principle they represent as a group, and then ask whether the modern statute is consistent with that principle. Not whether the modern statute has a historical twin. Whether it reflects a historically recognized principle applied to current circumstances. The Rahimi standard in plain English: history does not have to provide a carbon copy of the modern law. It has to provide the principle. The modern law then has to be a faithful application of that principle to present conditions. What Rahimi did not change: it did not restore means-end scrutiny. It did not give courts permission to balance public safety interests against the Second Amendment right. It did not make the government's historical burden lighter in general. It clarified that the burden requires principled historical reasoning, not a photocopied statute from 1791. Now let me show you the test in action, because the best way to lock this framework into memory is to watch it operate on 4 real cases. The first is United States versus Hemani, decided June 18, 2026, 9-0. Step 1. Does the Second Amendment's plain text cover Ali Hemani's conduct, keeping a legally owned Glock in his home while being an occasional marijuana user? Yes. The government conceded it. Step 1 goes to Hemani. The conduct is presumptively protected. Step 2. Can the government demonstrate a historical tradition of disarming occasional marijuana users? The government produced habitual drunkard laws, vagrancy statutes, civil commitment laws, surety bonds from the founding era targeting persons so persistently and pervasively incapacitated by alcohol that courts appointed guardians over them. Justice Gorsuch, writing for 7 of the 9 justices, rejected every category. The how did not match. Habitual drunkard laws burdened an entirely different class of person in an entirely different way. The why did not match. They were not aimed at occasional recreational users. The government failed Step 2, 9-0. The second case is Viramontes versus Cook County, cert granted June 30th, 2026. This is a Step 1 case, not a Step 2 case. The entire fight is over whether the Second Amendment's plain text covers AR-15 platform rifles at all. Plaintiffs say the common use standard is satisfied. 30 million owned, used for lawful purposes. That is all Heller requires. The government says the M16 and the like carve-out in Heller removes these rifles from the plain text before the historical analysis even begins. If the court rules for the plaintiffs at Step 1, the government then has to produce a founding-era tradition of banning the most commonly owned centerfire rifle in America. That tradition does not exist. The case almost certainly ends at Step 2 if plaintiffs win Step 1. The third case is Silencer Shop Foundation versus ATF, the NFA suppressor lawsuit pending in the Northern District of Texas. Even assuming suppressors clear Step 1 as arms, the lawsuit raises a Step 2 question of enormous scope. The One Big Beautiful Bill Act, signed July 4, 2025, zeroed out the $200 NFA transfer tax. The Plaintiff Coalition, including Gun Owners of America, the Firearms Policy Coalition, and 15 states, argues that without the tax, the constitutional justification for the entire NFA registration framework collapses. The government argues the remaining occupational tax and the Commerce Clause provide independent constitutional support. The district court has not yet ruled. The Step 2 historical analysis: is there a founding-era tradition of requiring federal prior approval registration before transferring a legal firearm between private citizens? Will be the center of that ruling. The fourth case is Wolford versus Lopez, decided June 25, 2026, 6-3. Hawaii required licensed concealed carry holders to get affirmative permission from property owners before entering any privately owned business open to the public. Step 1. Does the Second Amendment's plain text cover carrying a firearm into a business open to the public? Bruen itself established the right to carry in public for self-defense. Yes. Step 2. Can Hawaii demonstrate a historical tradition of requiring affirmative permission from property owners before a licensed carrier enters a business open to the public? Justice Alito, writing for the majority, found no founding-era tradition supporting a default prohibition on carry in ordinary commercial establishments, gas stations, grocery stores, coffee shops, laundromats. Hawaii failed Step 2. The law was struck down. 4 cases, 4 different laws, the same 2-step framework applied every time. That is what Bruen actually does in practice. Now let me give you the criticism of this test fairly, because your understanding of it is incomplete if you do not know why 2 Supreme Court justices want to scrap it. Justices Jackson and Sotomayor joined the Hemani majority result, 9-0, but filed a separate concurrence calling the Bruen framework unworkable and vulnerable to inconsistent and arbitrary application, as judges draw different conclusions from the same historical evidence. Their argument is not frivolous. History is not a neutral guide. Historians disagree about what founding-era laws meant, how they were enforced, and what they were intended to achieve. Judges are not historians, and the historical record is incomplete. The absence of a founding-era law banning something does not necessarily mean the founders believed it could never be banned. It might simply mean the problem did not exist in 1791 in a form that required a legislative response. Federal judges across the country have made the same point in their own opinions. One district court judge noted that taken to its logical extreme, the Bruen Test would require the government to produce a founding-era law specifically tailored to every modern category of offense. The example the judge used, a man convicted of selling pigs without a license in Massachusetts, a felony, would require the government to show a historical tradition of disarming pig license violators. That is, in the judge's own word, absurd. These are real tensions inside the Bruen framework. Lower courts are still producing inconsistent results under the same test, applying the same historical evidence to reach opposite conclusions. That inconsistency is exactly why Viramontes is so significant. The Supreme Court will have to sharpen how Bruen is applied to the AR-15 question, and the clarity of whatever it writes will determine how well the framework functions in the cases that follow. But here is the doctrinal reality that matters for your audience. Jackson and Sotomayor are 2 votes. They cannot overturn Bruen without 3 more. Justice Thomas authored the decision. Justice Alito joined it and has applied it in Wolford. Justices Roberts, Kavanaugh, and Barrett have all applied Bruen without questioning its validity. The 6-justice majority that created this test remains intact. It is the law. It will remain the law for the foreseeable future. Let me close with what this means for every gun owner watching this video. Every gun law passed by any legislature in the United States and every existing law currently being challenged is being evaluated under the Bruen Test. There is no other constitutional standard. Courts do not apply intermediate scrutiny to gun laws anymore. They do not balance your right against the government's interest in safety. They apply text, history, and tradition. That is it. Gun owners in banned states. Bruen is the reason the AR-15 challenge has constitutional traction. The question in Viramontes is not whether AR-15s are dangerous. It is whether a founding-era tradition of banning commonly owned arms exists. Plaintiffs argue it does not. If they are right on Step 1, the government almost certainly cannot meet Step 2. The Supreme Court will answer that question by June 2027. Gun owners facing federal gun laws. The Hemani ruling showed that even a unanimous court applying Bruen produces a narrow, fact-specific outcome. The test does not automatically strike down every gun law. It requires case-by-case historical analysis. Every Section 922G prosecution, every state-level purchase restriction, every magazine ban, each one is now a separate Bruen inquiry with its own historical record and its own Step 1 and Step 2 analysis. And the compliance point that closes every video on this channel bears repeating here. No gun law is automatically invalid because Bruen exists. A law is unconstitutional only when a court applying the Bruen Test finds that the government cannot meet its historical tradition burden. Until a court enters that ruling for a specific law in your specific jurisdiction, the law remains fully in force and fully enforceable. Understanding the Bruen Test does not change your compliance obligations. It changes your ability to follow the litigation that is reshaping American gun law, case by case, step by step, from the Northern District of Texas to the Supreme Court of the United States. That is the test. That is how every gun law in America gets decided now.